Well, it looks like everyone's here, so we'll proceed to the next case. Gregory Brown, Santa Rosa County Property Appraiser versus City of Gulf Breeze. We've scheduled 20 minutes per side, or 15 minutes per side, excuse me. Counsel for appellant may proceed.
Thank you, Your Honor. And my name is Lauren Levy, and I represent Greg Brown, who's the Santa Rosa County Property Appraiser. And if I could, before I begin, can I please reserve 3 minutes for rebuttal, sir?
Yes, thank you.
Thank you, Your Honor. Your Honor, this case is an ad valorem tax case, and it involves the taxable status of certain golf course facilities that are owned by the City of Gulf Breeze. But
Mr. Levy, I'm sorry to interrupt you so quickly, but you both wrote excellent briefs in this case, and it's a fascinating issue. One argument your opponent makes is that under your argument, the city can, or a city can never outsource to a private entity to manage its property. That's a correct statement with your argument, right? A for-profit entity.
I believe with this caveat, Your Honor, if a city allows a private entity to use its property in a for-profit proprietary manner, then yes, the Constitution requires taxation.
So anytime a for-profit organization, a management company, I mean, this is a fairly routine business model in the private sector and becoming more and more routine. So under your argument, a city can never outsource to a for-profit. I'm not sure a management company could be not for profit. They may try, I guess, down the road, but it could never outsource to a for-profit company to operate a swimming pool, a golf course, a marina, to save taxpayer dollars.
Yes, sir. They're not allowed to do that under the Constitution. The Constitution requires taxation of those facilities under those circumstances, Your Honor. Okay. And if I could follow up with that, Your Honor, we've got a long line of these cases, and we tried to put all of those in our brief. The legislature, the Supreme Court has said several times, would not have any authority to attempt to adopt a statute that would allow an exemption for city-owned property when used by a private party, if you would, Your Honor. And we certainly would suggest that if the legislature could not do that, then certainly private parties may not contractually do that. We think it's very clear that if the city had leased the golf course facilities to Integrity Golf, they would be taxable. And the city cannot avoid that obligation via the mechanism of a management agreement. And Your Honor,
I thought every case that's addressed this issue said that they can. What case?
I'm sorry.
I thought every case that I've read says that they can in Florida. What case says that they can't? In other words, hey, if the city wants to outsource the mowing of the shoulders along right-of-ways to a for-profit lawn mowing company or maintenance company, why can't they do that? I mean, where does it say they can't do that?
Judge Makar, the city certainly can do that. They can hire independent contractors to maintain the facilities. What they can't do is provide a possessory interest, if you would, in those facilities to a private contractor to use the facilities to generate business profits.
Well, you say possessory interest. I mean, they don't. In this case, they don't own or control the property, do they? The management company.
I believe the management company certainly has a possessory interest in these golf course facilities, Your Honor. They are the only entity that's allowed to run the golf course facilities and generate a profit therefrom.
Does that give them a legal interest in the land?
Yes, sir. They have an interest in the land. They have an agreement that says for 7 years, subject to 2 5-year renewals, they will be the only entity that is allowed to use the golf course facilities, which is the course, the bar, the restaurant, pro shop, to generate business profits. Yes, sir, Your Honor.
Well, I guess I'm reading a different order because the trial judge's order seemed to suggest that the city had the sole right to control the property.
the city, like, and we're kind of into the argument, Your Honor, about is this a lease or a management agreement?
Right.
But the city certainly retained, I would suggest, obligations typical of any landlord, that they have the right to control the use of the property in a certain respect.
So your argument is that the trial court erred in construing the management agreement, and it should be a lease.
Certainly, Your Honor, that's our second argument there. Or I guess another way you could look at it would be that it would be unnecessary to reach the argument of, does it matter whether the use under the constitutional provision is pursuant to a lease versus a management agreement, if you concluded that the agreement in this instance was in fact a lease. And
What do you say
I would
to the
add,
argument? What do you say to the argument of the city that, well, look at all the prerogatives we retained, signage. I guess they have control over what kind of golf balls the management company can sell, fees to charge to the public. You know, all these elements of control. Would you concede that it's, regarding Judge Makar's question, there are a lot of elements of control here retained by the city?
yes, Your Honor, I certainly would concede that the city has retained some level of control that is a bit further than what a typical landlord would retain. But in sum and substance, what is going on here? Integrity Golf is paying rent to the city for the right to use the golf course facilities for a 7-year term with 2 5-year extensions to generate business profits for itself. And that requires ad valorem taxation, Your Honor.
And the minimum rent is $100,000.
The minimum rent is $100,000. And then if there are certain gross revenue thresholds met, there will be additional amounts owed under the contractual obligation. So in effect, the city is sharing in the profits being generated by this property.
Counsel, let me, if I could, that touches on a point I wanted to ask you about. So you conceded in your brief that it was okay when the city was operating the golf course. That was exempt activity. And I believe you made that concession despite the fact that clearly the city had every intent of turning a profit. They just admitted that they did a terrible job at it and weren't turning a profit and were running a loss. And that's why they ultimately went with Integrity Golf. So is it okay for a city to run a golf course that it owns for its own profit, so to speak?
Your Honor, I believe that's been answered in the affirmative. The Treasure Coast Marina case would have addressed that. A case that was cited in Treasure Coast Marina, the Islamorada case, specifically addressed that and said there's nothing wrong with the city making profits when it is using the marina itself. But when it allows use by another for-profit entity to generate business profits, a separate test for exemption is applicable. And under the Constitution, we would suggest taxation is required.
So it would be okay then, it would remain exempt if the city hired a consultant to help it be more profitable in running the golf course. Do you agree with that?
I think the city could hire a consultant to give it advice on how it may better operate the facility. But when the city turns the facility over to a third party for-profit contractor, let's call them a contractor, and tells that contractor, you are allowed to run the golf course and generate business profits from that entity is using government property for proprietary purposes, and taxation is required, Your Honor.
Let me ask you, counsel. So,
yes, sir.
Let's say a clever management company says, well, we decided that we are a nonprofit management company. We're going to pay all our chief executives $1 million a year, and we're going to ensure that we never show a profit. We'll pay the city the minimum $100,000 lease, but please be on notice that we will not accept filthy lucre, and we are a nonprofit management company. What would your argument be there?
That the sum and substance of what that entity was doing was for profit and for profit making purposes, Your Honor. You know, we're throughout taxation, we're always looking for what is truly happening here. We look at the form and not the substance. And so our argument on the use of this property here really begins and ends with the plain language of the Constitution, which says all property owned by a municipality and used exclusively by it. And here factually, we have to acknowledge that this property is not used exclusively by the city.
But it's for a municipal. It's for a municipal purpose. You have to concede that.
No, sir. Once and City of Gainesville.
Golf courses aren't for municipal purposes.
They are a permissible municipal purpose when the city is exclusively using the property, Your Honor. That's what the City of Gainesville case says. When the city turns around and allows a for-profit entity to use its property to generate business profits, that's a proprietary use and it is required to be taxed. The City of Gainesville gave us an excellent discussion of why that is.
Is the same case with a sewage treatment plant? A sewage treatment plant? Same
yes, sir. I would submit that it would be the case. We've not had that situation happen in the case law, but it would be the case if you're allowing a for-profit entity to use city property, it should be taxable. If I could go back, for example, the Page versus Fernandina Beach case. This court has observed that when the city owns and uses it exclusively, that marina is exempt. But when the city leases that property out to a for-profit entity.
Well, you just used the word lease. There's not
yes, sir.
But there's not a lease here. You're arguing there is, but the trial court found otherwise.
Well, the trial court found otherwise, and that's a legal determination. And Your Honor, I would hope that the court would look at the agreement closely and see that it is a what's described as a management agreement masquerading as a lease. And Your Honor, if I could suggest, to the extent there were any ambiguity or reasonable doubt as to how we should construe this agreement, it must be construed in favor of taxation and against exemption. But the City of Gainesville case, the Treasure Coast Marina case that I handled, those two cases very clearly say when the city is owning and using the property exclusively by itself, that definition of municipal purposes would include a golf course, Your Honor. But when the city allows a private for-profit entity to use that same facility, regardless of the terms of the agreement, Your Honor, it's required to be taxable. The Florida Constitution doesn't say anything about a lease. There's no use in there about a lease. And that's where we believe the trial court really went wrong. It's very clear that provision is self-executing. And the trial court.
So is your concern how Integrity splits the fees? Like if instead the city paid Integrity every month to provide a service like running this golf course, and any profit, I mean, any money made at the golf course was turned over to the city, would you be taking the same position that this was not exempt property?
I think that's a much different position, Your Honor. Yes, sir. Now that also goes into, that cuts both ways. Is this really a lease or a management agreement? It goes to that argument, because typically a management agreement would involve a payment of a fee to a certain entity.
Well, it sounds like you're just taking the approach that whatever the reality is on the ground, whatever the label is, doesn't really matter as much as what's actually going on. What type of activity is actually happening there?
I would certainly agree, Your Honor, and that's a bedrock principle of ad valorem tax. In fact, all tax matters is substance over form. You have to look at what is really going on out there on the ground, and move forward through that. Your Honor, I want to be sure that I talk about the City of Sebring case in 2001 out of the Florida Supreme Court. That case involved kind of the second visit of the City of Sebring Raceway to the Florida Supreme Court in 1994. Florida Supreme Court had said that the property that was leased to a private for-profit entity was subject to taxation. The legislature then attempted to pass a statute to basically overturn that decision. And the wording of the statute was that the use of city-owned property, and I'm paraphrasing here, by any licensee, lessee, or management company, and then it described a list of the purposes, would be deemed municipal purposes. The Florida Supreme Court held that entire provision unconstitutional. If the city's argument is correct here, Your Honor, that the lease is the sole thing that makes a difference, the Florida Supreme Court would not have been necessary for them to hold the entire statute unconstitutional. They simply would have said, well, to the extent a lease is involved, the statute is unconstitutional, but we can preserve the constitutionality when we're talking about licensees or management companies. The court didn't do that. It also went on, Your Honor, and bookended.
Counsel, I think you've exceeded your time.
Oh,
So
I'm very sorry.
that's okay.
I'll
let you
It is a
go.
little small.
I'll let you go.
But I was going to say that the Supreme Court bookended its argument with the other provision in the relating to bonds that talk about leases or contracts. Thank you very much.
Thank you, Counsel. So I'd ask the clerk to award another minute 24 or so to the appellee's time. Actually make it 2:24, and I'll give the appellant another minute to conclude, to rebuttal.
Thank
So
you, Your Honor.
2:24 in addition to appellee, and one more minute for appellant. Let's give the clerk a minute to figure that out. There we go. Appellee, thank you, Madam Clerk. Appellee may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court, Mr. Levy. My name is Todd Harris, and along with my co-counsel, Ed Fleming, I have the privilege of representing the City of Gulf Breeze in this matter. And of course, Your Honor, we believe the trial court correctly found that the agreement between the city and Integrity was, in both substance and form, a management agreement and not a lease. And in doing so, it applied the basic common law tenets of what does and does not constitute a leasehold interest. The fundamental characteristic of a lease is that it conveys the exclusive right of possession and control over the premises to a tenant during the life of the lease. Gray v. Callahan, a case we cited from the Florida Supreme Court, says, quote, during the life of a lease, the lessee holds an outstanding leasehold estate in the premises, which for all practical purposes is equivalent to absolute ownership. The estate of the lessor during such time is limited to his reversionary interest, which ripens into perfect title at the expiration of the lease, close quote. Put another way, Your Honor, the essence of a lease is that during the life of a lease, the lessee looks like the owner. In this case, the trial court correctly concluded by looking at the plain language of the management agreement and the undisputed record evidence that Integrity did not look like the owner. And that's because the management agreement was specific about the rights that it was and was not granting to the management company. And of course, we've given a litany of those examples in our briefs, and I'll touch on just a few of them here.
Counsel, if I could ask a question, is there any evidence that the private company is making lease payments for use of the facilities, or is it just a management fee?
None. There's no evidence that it's making lease payments, Your Honor. The management agreement sets up the pay structure so that it is so that the way that the management company is paid is that it retains any profits that it might take in as it's essentially its payment of its fee for the services being provided to the city.
Okay, and as I understand, the management agreement doesn't have any right of control over the property by the management company. It just has the right to use and access.
Yeah, in fact, it specifically grants the right of access to the management company, to the parking lot and the facilities for purposes of providing services to the city. And the city specifically retains control to do anything on the property that it otherwise has the right to do. And it retains the right to access the property at any time for any purpose.
And the golf course is open to the public, correct?
Yes, sir, it is. And that's mandated by the management agreement. And the city establishes the days and hours that the golf course has to be open.
Okay, because it looked as if the property or the golf course was surrounded by private properties, like private residential properties. But the fact of the matter is the property itself is city owned, and the bordering adjacent properties are all privately owned.
You're correct, Your Honor.
Okay, thank you.
Counsel, what would you call the $100,000 or the 5 or 7% of gross that Integrity pays to the city? You said it's not rent, so what is it?
It is the amount that the management company pays for the right to essentially be on the property and provide services to the city, Your Honor.
Gosh, that sounds a lot like what a tenant does when they pay rent to a landlord, is the right to be in that apartment. So why is that different?
Actually, Your Honor, and we cited the court to in the matter of Dabin Corporation, which is a case out of a federal court, which is persuasive authority on the issue, in which a fee was also paid as essentially a license fee that granted the owner and operator of a children's store to operate within a retail space. He paid a percentage of his revenues to the owner of the facility for the right to operate there. The owner of the facility later argued that it was a lease payment. In applying common law principles, the same common law principles that are at issue here, the court said no, that is not a lease payment or a rent payment. That doesn't decide whether an agreement is or is not a lease agreement. What decides whether an agreement is a lease is the substance of the possessory right that's granted. It has to grant exclusive possession or control. So regardless of what the payment arrangement might be, or the payment structure of any agreement, that is not determinative of whether or not it is a lease or is not a lease.
Well, that would be true if lease was mentioned in the Constitution, which it's not. So I'm curious why I would be looking to common law principles to figure out whether what the city is actually doing here fits within the exemption or outside the exemption. If the reality is, whether it's a lease or a license, and I'm not sure how characterizing as a license helps you, because either way, what you said is that Integrity is paying the city for the right to be there on the property and run a business and presumably make some money off of it. So how does that differ from, how is that not a governmental proprietary function, whether you call it a lease, a license, or something else? If the activity is achieving a government purpose or being on government property and providing a proprietary function, why that doesn't put it outside the exemption?
Well, a couple of things, Your Honor. First of all, the governmental versus governmental proprietary test only applies where there is a leasehold interest involved. And
well, I mean, I know that the cases talk about it in that concept, but what is the origin of that distinction? Like, is there something in the Constitution that says that we can't consider that paradigm in the context of the broader language of the Constitution?
Well, that's what the Florida Supreme Court has said, Your Honor, in Treasure Coast Marina and in cases that the court relied upon there as to the test that we're to look to when we're deciding under Article 7, Section 3, whether a municipal exemption is appropriate or not appropriate. And in Treasure Coast Marina, the Florida Supreme Court said if it is owned by the municipality, if it is open to the public, and if it's operated by the municipality for a municipal purpose, then it is entitled to an exemption under Article 7, Section 3. And that's exactly what the trial court found in this case, Your Honor, and we think correctly found in this case.
Well, based on what facts specifically indicate that the city was operating this golf course? Because I think the facts are that it was Integrity's employees that are occupying the place and running it on a daily basis. It is Integrity that's responsible for the property taxes, by the way. It is Integrity that's responsible for the costs. It's Integrity that's responsible for the capital improvements. So what part of what facts indicate that it's actually the city running this golf course?
Well, Your
I would
Honor,
take it outside of that paradigm that, in Treasure Coast and Sebring and the others.
the facts on the ground and the unrebutted testimony before the trial court, for example, from Ron Pulley, who was director of Parks and Recreation, was that the only thing that changed after Integrity was hired as the management company was that instead of being on the property every day, he was there 2 to 3 times a week supervising Integrity, checking on the golf course operations, and that he met with them every week.
Right. What he said is he was operating as a contract manager instead.
That's correct. He was overseeing, of course, as the city, overseeing the city's agent. So instead of the city having W-2 employees on site working, it had an independent contractor on site working, being overseen by the city's employees. So the city, not only did it have its director of Parks and Recreation that was weekly, multiple times a week, overseeing the operation, but of course, under the substance of the management agreement, it had control over the rules that govern the facility. For example, the city approved the kind of clothing that could be worn at the city. It even controlled how loud the employees could listen to their radios on site. It affected what could be sold, or controlled what could be sold at the facility. It controlled, most importantly, because the most important thing about this property to the city was its use as an effluent field to spray brown water. It could use the facility at any time, day or night, and to spray any amount of effluent on the golf course. And that was the city's right, regardless of what else was going on the golf course. So it was, Your Honor, and in almost every way, except no longer using W-2 employees, it was operating the golf course, both in the form and substance of the management agreement and in the on-the-ground activities.
So, Counsel, is it your position that Treasure Coast and the cases that preceded it, Sebring 1 and 2, that categorically the paradigm set out there about government versus government proprietary functions, that categorically does not apply to, say, like a license or anything besides a lease?
I believe that's the Sebring governmental versus governmental proprietary test, Your Honor, does not apply. And I think Treasure Coast makes this clear, does not apply. Whereas in this case, the municipality owns and operates a facility that's open to the public for a municipal purpose. So
change the facts in Sebring, or pick a case. Change the facts such that it's no longer a lease. But on the title at the top, this is an exclusive license. Suddenly, and everything else stays the same. The licensee gets exclusive use to use the property to turn a profit. That suddenly falls outside the paradigm, and that would be exempt activity. Is that what you're saying?
Well, Your Honor, looking at the substance of the agreement, I think if you start getting to an exclusive use and possession and control of the property, regardless of what you call it, it could be deemed a leasehold interest, which would—
No, I said just exclusive license. So the city would still own the property. It provides an exclusive license. It means that no one besides Integrity can come on that property and use it to run proprietary activities, aside from, of course, the city. But you're saying that this whole analysis that is talked about in Treasure Coast and the other cases goes out the window, and it's categorically exempt because the city did not lease the property to someone else.
I am saying that in the scenario that you mentioned, Your Honor, where the municipality continues to have the right to own and operate the property, even though it may have an outside entity, in this case like Integrity, that has the right to manage the property for the city, it does not fall into Sebring paradigm.
Well, it seems like we have semantics here. I mean, a typical management company gets paid a fee to do a service. It's not what we have here. We have an entity that gets to come on the property exclusively for 5, 7, or whatever years and do a lot more. They can run the property, they can turn a profit, they can do capital improvements, they have to pay the taxes, they have to pay the costs of the incurred in the business, and they have to pay the city $100,000 or 5 to 7% of gross every year for the opportunity to do that. So I'm having a hard time understanding how this is purely just management of the city's golf operation.
Well, Your Honor, I mean, I think that the important analysis of that is not whether it looks exactly like a traditional management agreement, but whether or not it in fact grants a leasehold interest in the property to the management company. And I believe the trial court was correct in finding that it does not grant such an interest. And therefore we have to look to what does Treasure Coast Marina, for example, tell us about how the property should then be treated under the facts that were before the trial court. And we believe that it has met the Treasure Coast test for determining a municipal exemption.
Right. Thank you.
Thank you, Your Honor. I appreciate the questions.
Hey, Council, is there an analogy between, say McDonald's owns the real property? That's typically the way it is, and a franchisee comes in and just operates it. McDonald's owns the property, has great control over the franchisee, signage, what you can sell. Is there an analogy there? Is that sort of what you're arguing?
Well, the analogy on the control issue, I think, is correct, except this isn't even, I think, more, there's even more control being exercised in this case because of the degree of right that the city has to be on the property at any time for any reason to do anything that it would otherwise have the right to do if the management company wasn't there. And that especially comes into play with the ability to control the property for purposes of disposing of its effluent whenever and however it needs to do that.
Well, let me ask you this. The management company can't do anything on its own as to the property. It can't change it. It can't, right? Okay, it has to get city approval. And then there's many aspects of what it does do in terms of managing that the city controls as well. Yeah, the merchandise that's sold, the advertising, the signage, employee discounts, point of sale equipment, it goes on and on. And it says there's rules and regulations as well that the city has imposed upon it. So where does the management company actually have any discretionary authority over the control and use of the property?
It's not much, Your Honor. I mean, there are some, obviously in the day-to-day operations of, and I think some of the substance that was before the trial court, and that's in the record before this court, is they made decisions about when to water, normally when to water the golf course. They were the ones that handled and sort of established some of the methods for, how we handled, receipt of the greens fees, all those kinds of things. But even the point of sale, even the cash register, for example, had to be approved by the city. You couldn't give an employee discount. Integrity couldn't give an employee discount without reporting that to the city. So the depth of control that the city had over supervising the operations was extensive, Your Honor. And so with that, I want to return, I guess, back to Treasure Coast Marina for just a minute and point out that Treasure Coast Marina cites with approval this court's decision in Zingali versus Crossings at Fleming Island. And in that particular case, the district, which was treated as a municipality for tax purposes at that particular time under Florida law, used a management company, East West Partners, I believe was the name of the management company, to operate its golf course. This court approved the municipal exemption that had been given there, finding that appropriate, in spite of the fact that the municipal district used a management company to assist it in operating the property. And in Treasure Coast Marina, the Florida Supreme Court noted with approval this court's analysis of how the municipal exemption was handled in that case. The four questions, Your Honor, established by the Florida Supreme Court: is it owned by the municipality? The answer to that is yes. In this case, is it open to the public? Undisputed that that's the case. Is it operated by the municipality? We submit to you that it is. Does it serve a traditional municipal function? I don't think that's disputed anymore either. And that's the appropriate case. That's the appropriate test when no lease is involved, and no lease is involved in this manner. And we ask that you affirm the trial court's judgment in this case. Thank you, Your Honor. I believe my time is up.
Thank you, counsel. Rebuttal.
Yes, Your Honor. And Treasure Coast Marina very clearly said that that rule only applied when the property was being used exclusively by the city. And in these facts, it's very clear that the property is not being used exclusively by the city. Judge Tannenbaum, you asked.
What do you say to counsel's position that the whole paradigm goes out the window if this is not a lease? So I guess if it were a license or an exclusive license, we wouldn't be applying that test at all. I read Sebring 1 and 2 as and Treasure Coast as being a little bit broader and talking about uses and how it's being used. What do you say to counsel's argument on that?
He's absolutely wrong, Your Honor. The Florida Supreme Court has repeatedly said we're going to rely upon the function by utilization case or test. You had asked, what if the facts were different in any of these cases? Well, let's take the Sebring case. What if the use was pursuant to a management agreement? Would the Supreme Court have held the statute unconstitutional that said the use by a lessee, licensee, or management company could constitute a municipal purpose? The court held that unconstitutional. So if it were a management agreement in that case, we would be in the same place, which this case is not just an esoteric exercise in governmental exemptions. This is important. If there were such a loophole, every city would simply structure its agreement with any private entity as anything but a lease.
Counsel,
and avoid the Constitution. Thank you very much.
I'm going to try and be fair to both sides on the timing. Thank you both for your arguments and excellent briefs. And with that, the court will be in a short recess before the final case.
Thank you, Your Honor.
Thank you both.